Alright. Ready? The last part is terrible, totally qualified, and only quotes Scalia. This evidence is not conclusive, and it is not specific to the specific bill or the counterplan passes. It's in the tribe evidence, which is the only evidence specific to increasing freedoms as opposed to banning abortion. EPA at the top, they've conceded the impact determines the case because climate change increases gender roles. Women are most vulnerable in times of environmental crisis. That the raw evidence also leads to extinction. That should not and high and we control the debate on magnitude. If we win, a decent probability that data is sufficient to outweigh the case, especially because the counterplan mitigates any probability deficit. They say controversial now. This evidence does not say they'll controversial. It just says that they'll come up, and abortion dwarfs these issues. These issues are not the issues of fundamental controversy. One of the issues it cites is the EPA. The other ones are abortion and desegregation, but the court will maintain the status quo on these issues. Store 927, court observers, a question whether Roberts go along with decision overturn the abortion affirmative action given institutional role and his new tenure. I don't think he wants to send the consummation. It's really said that the lawyer and Roberts court is reining in both liberal and conservative activism. Pittsburgh focused at 620 conservative majority in this report is likely to get the danger of overreach from the right. Roberts seems to be setting his face against judicial activism, and Roberts and Alito respect says no overrules. Lane 10-1. Roberts and Alito pledge to vote in ruling constitution. They want to make it like it's the bullying reasons to change their different people's lives. A professor of law at the UNC, and there's no evidence the public will perceive any of his decisions are. Link card proves that the public will perceive the plan because they agree with the compromise, the Casey decision, and Star decisive strong. Lester 6. Roberts Alito car press to the legal jurisprudence. Roberts said he never on Professor Alito told he is tremendous. Professor is approach not to overcome the case to decrease how they're really decided both are in stark contrast with time. It's a group their Kennedy doesn't care. This evidence just says he's a philosopher. It's terrible. Doesn't answer the controversy internal link that's Peretti, which is specific to the entirety of the Supreme Court, and their ABC evidence proves the internal link because it says that he is the swing vote, and Kennedy perceives the court's judicial capital as finite and drained by overruling landmark decisions. Record of more Kennedy's judicial behavior is concerned with the voting the court's political capital just be unlikely to agree on too many decisions that will lead to giving back to the court. This decision have been reflecting undue concern with the court's political capital. Casey refused to overrule Rome, motivated by fear for the capital of the court is much safer for the court to approve the precedent, and Kennedy's key to mass EPA left in 6 and Rockman of the court issue divided opinion. The decision highlights the importance of Kennedy's swing vote and Rockman's refusal right for belief for Kennedy's as an attorney for the Sierra Club. They say Alito is key. This evidence assumes partial birth abortion, not the plan, and is not about the EPA. Even if he's not the swing for the plan, he'll still get really angry. That just magnifies only because it proves that he'll fight the rest of the court. He'll fight Alito in an attempt to preserve a majority in opposition to the plan, but in the end he'll lose. That will make him less likely to vote for the EPA case. That at most that also just proves that Alito will be the swing vote in the EPA case, and they'll change that as well. Extend our 1 and C internal link, which is specific to the entire court. That's Peretti and Kennedy doing perceived overruling Casey's killing legitimacy. Stewart and Hugh Clinton concerned abortions. O'Connor with the joint opinion for Kennedy opinion emphasized the need to uphold precedents under Starr and cites the legitimacy of the court or state as vacillation and reproductive rights empirically destroyed court capital. The cell 2 reproductive rights, one of the classic examples. A dilemma the Supreme Court faces the Supreme Court bench is magnified to the wrath of the sizable portion of the Republican Congress. They say fiat solves that argument. It's just another legal argument which is answered above. They say controversy doesn't generate political capital. This evidence just says it doesn't cause the rule of law to break down. Does not assuming the way internal court politics function and judicial capital is finite. Justice terrifying controversial issues grab cause 998. Any claim the Supreme Court is fully immune to backlash and controversial issues can be rejected on a private page level. Supreme Court's mode of operation suggests that justice view institutional support as an expensive political capital. The court recognizes the political limitation. Justice pick the spots carefully when approaching potentially controversial cases. Should justice trade cautiously so as to keep backlash from minimum and institutional capital is limited. But now we prove the political process from the application of power of the court should not intervene. The court's limited institutional practice for the capital rights of individuals. Little recourse in the democratic process. They say are evidence from the 70s. They don't answer the global warming internally. Even if this takes out efficiency, they have no evidence that won't increase fuel efficiency. Prefer the duty evidence, and there's no way whether it's a factual way that that's the only way they can produce CO2. They say improve the Hamdan, but Hamdan had no lasting effect. Alt 6, the Hamdan had a little effect. Congress is very clearly to get rid of the provisions of authority to utilize military commissions, and that was in the past term. Our internal link evidence proves that this term is key because one bombshell at a time is enough, but past decisions are irrelevant. They say a court group their arguments as to why the court decision has no lasting impact. This evidence just says that regulation is inevitable because of the states, but massive EPA's key to the success or failure of the overall U.S. approach to climate change. McClatchy Tribune 10-6 proposal comment global warming cropping up the trend is in the right direction. The wrong Supreme Court decision to put a chill on climate policy nationwide. Massive EPA's are hasten U.S. mitigation. A greenhouse gas emission brings forward disappointing halt can have enormous repercussions about standing in future environmental cases, and ruling for the EPA would gut state emissions regulations because of the warrant their evidence. All 6 cases important mitigation, state action, and climate change that allow the states exceed EPA standards not wander and territory deemed off limits vehicle emissions to the main point of contention in California, and 10 other states have followed suit, held up by litigation. Around 9% hinges largely on what happens in the Supreme Court case, and the EPA would regulate CO2. It doesn't need much forcing. Adler 2 indicate EPA might not need to enforce these already on record and declaring carbon dioxide meets the CA's definition of air pollutant. EPA can move forward with regulation, and even if they win these arguments, it just proves that regulation will take a little while. They make a uniqueness argument here, but the court will rule in favor of the state's L4 and 6 EPA could break the that's the time for regulation of the U.S. global warming conversation. If the case moves to the court rule in the state's favor, the issue is not a matter of if or when, and Anderson will want to see uniqueness evidence is most conclusive. In case that they will force them to regulate in the status quo, and the Supreme Court ruling in favor of the states is all but definite. The status quo applies inside energy. The Supreme Court decision to the case sparked strong reaction in Capitol Hill. The Supreme Court wanted to reaffirm EPA's position to do so, but simply refused to take the case. It was only an upside high court's decision, and the states are likely one badger hair newly filed, not other. The court could uphold EPA's claims as unlikely more likely option is for the court to reverse the lower court's decision. They say calculability bad. This evidence is terrible. It says we shouldn't be too pessimistic and should take pragmatic action. This is precisely what we're doing. We say we should do that through Congress and the EPA. This evidence is also about nuclear war, not the case, and calculated decisions are essential to avoiding cruelty. Others will calculate. We must too. Campbell 99. Undecidable decision, not avoidance. Urgency barriers for a just decision is always required immediately right away. The pursuit of information and limited knowledge condition that could justify it are unavailable in the crush of time. Dare to argue for the necessity of the madness that justice exceeds law and calculation cannot and should not serve as an outline for staying at juridical battles with institutions stable. Indeed, incalculable justice requires us to calculate left outside. Incalculable idea of justice is always very close. At worst, can be reappropriated for the most perverse calculations necessary to calculating the incalculable respond to a duty that compels the decision to avoid the worst of the duty response to the practical political concerns when recognized the argument for the bad, perverse, and the worst of violence recognized without having yet thought them through the crime of xenophobia, racism, and anti-Semitism, religious or nationalist potato system, and the fact that we have a counterplan means we can solve.